My name is Pip Nicholson. I'm the Dean of the Melbourne Law School, and I'm delighted that we are now fully wired. So welcome to one and all. Can we start tonight's proceedings, please, by acknowledging that we meet on the land of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders past and present, and indeed to any Indigenous peoples that are joining with us this evening. It's obviously an extraordinary pleasure to welcome such a large group, such an enthusiastic group, and dare I say it, such a tolerant group given our hiccups as we set off this evening. I would particularly like to acknowledge the presence of our distinguished guests, the Southey family, and indeed, of course, our guest speaker, the Honourable Justice Stephen Gageler AC of the High Court of Australia. I'd also like to acknowledge another group who've joined us this evening. We are pleased to welcome the Solicitors Generals from the States and Territories of Australia who are here for their own conference but have decided to join us to listen to the words of wisdom of our guest speaker. So a heartfelt welcome to you all also. These sorts of events don't come together by themselves, and I would like to pay very brief tribute to two of my academic colleagues, Professor Adrienne Stone and Associate Professor Kristen Rundle. Both women have been instrumental in both securing our speaker, designing the program of the conference that you've convened to debate issues of constitutional law tomorrow, and also generally leading the constitutional and public law program of this law school over a sustained period. For those of you who don't know, Adrienne Stone is the Kathleen Fitzpatrick Australian Laureate Fellow. She's also a Redmond Barry Distinguished Professor and Director of the Centre for Comparative Constitutional Law Studies at Melbourne, and Kristen is its Deputy Director. Tonight's lecture is co-hosted by the Centre for Comparative Constitutional Studies and officially commences the 2019 Constitutional Law Conference. Can I thank those of you who've travelled, and some of you have travelled a very long way, for doing so and for joining us both tonight and at the conference tomorrow. Can I also let you all know that tonight's lecture will be photographed and also taped. If you don't want to be included in the photography, please let my staff know. It's also the moment at which I encourage everyone to turn off their mobile phones. I trust my own will not peel inconveniently, but it's a good moment to double check yours if you're uncertain. Tonight's lecture forms part of the Alan Hope Southey Memorial Lecture Series. This is an annual lecture series that was established in 1958 by Ethel Thorpe Southey, more commonly known as Nancy Southey. And the aim of the lecture series was to endow a lectureship in memory of her husband, Alan Hope Southey, who graduated as a Master of Laws at the University of Melbourne in 1917. Over 50 years later, the Southey family, many of whom are here tonight, continue to support this lecture, and we'd like to thank them specifically for their generous donations. Many of you may know that the first Alan Hope Southey lecture, titled The Challenge to Federalism, was presented in 1960 by the late Sir Robert Menzies. It is, therefore, fitting tonight that our lecture will reflect on the heroes behind the landmark decision of the High Court of Australia in the Engineers case, among whom were, of course, Sir Robert Menzies, counsel for the successful party. It's no surprise to all of you that tonight's lecture will be delivered by the Honourable Justice Stephen Gageler, AC of the High Court of Australia. We were also fortunate to host Justice Gageler for the 2016 Alan Hope Memorial Lecture, when he presented a fascinating critique into the historical episode when the High Court went on strike. Before asking Justice Gageler to share his unique sights into the Engineers case, I'll make a few brief remarks by way of introduction. Justice Gageler is a graduate of the Australian National University and has postgraduate qualifications from Harvard University. He was admitted as a barrister of the Supreme Court of New South Wales in 1989 and was appointed senior counsel in 2000. Before his appointment as Solicitor General in 2008, he practiced as a barrister extensively throughout Australia, principally in constitutional law, administrative law, and commercial law. Justice Stephen John Gageler was appointed to the High Court of Australia in October 2012, and at the time of his appointment, he was the Solicitor General of Australia. We are very fortunate indeed to have you back with us again tonight, Justice Gageler, and it gives me extraordinary pleasure to welcome you to what I hope is a fully mic'd podium.
Well, thank you very much for that introduction. Can you hear me? Good. I'm wired and ready to go. Members of the Southey family, faculty, students and friends of the law school at Melbourne University, Solicitors General, past and present, you get to listen to me today. Old colleagues and old adversaries. I see also in the audience, and those categories are by no means mutually exclusive. It's very good to be here. The title of this lecture has been inspired by a recent biopic in which our hero, Ruth Bader Ginsburg, embarks on a quest to have the Supreme Court of the United States recognise discrimination on the basis of sex as a violation of the Equal Protection Clause and of the Due Process Clause within the Constitution of the United States. The climax is a courtroom scene in which the earnest young Ginsburg manages to convince a sceptical but well-disposed, middle-aged, all-male bench of the 10th Circuit Court of Appeals to take the necessary first step. A notable refrain in the film is a line attributed to a great American constitutional scholar of the mid-20th century, Professor Paul Freund, who had taught Ginsburg at Harvard Law School. The court should never be influenced by the weather of the day, Freund is reported by Ginsburg to have said, but inevitably it will be influenced by the climate of the era. 25 years ago, I participated in a seminar to mark the 75th anniversary of the engineer's case. The seminar was at University House in Canberra, and it was organised by the late Professor Michael Coper and the now and still vigorous Professor George Williams. One of the speakers was the late Professor Leslie Zines. He had taught me constitutional law at the Australian National University 15 years before, and 25 years before that, he had himself been a student of Freund at Harvard. Professor Zines' masterful book, The High Court and the Constitution, was at that time in its third edition. The first chapter of that book contained the clearest and most comprehensive exposition that had until then been written on the engineer's case and its place in our constitutional history. Nothing published since has eclipsed that account. Another of the speakers was the evergreen Professor Tony Blackshield. He commenced by confessing to have been troubled all day by what he poetically described as a nameless anxiety fuelled by the fear that there was nothing that could be said about the engineers' case that had not already been said by distinguished lawyers over the preceding 75 years. Preeminent amongst the eminent speakers at that seminar 25 years ago was Sir Gerard Brennan, then Chief Justice of the High Court. He commenced with the observation that whenever there is a case to celebrate, there is a kind of legal champion to praise. Who were the heroes, or more specifically, who was the hero of the engineers' case, he asked. Was it counsel for the successful party, the precocious 25-year-old Robert Menzies? At the time of the engineers' case, in his second year of legal practice at the Victorian Bar, having just completed his pupillage under the tutelage of the Victorian Bar's most fashionable junior, the 34-year-old rising star Owen Dixon, appearing on his own in his first big case before the High Court, and prevailing over more numerous and more senior adversaries, who included Sir Edward Mitchell KC, the undisputed leader of the Victorian Bar, leading the 42-year-old John Latham, and who included as well George Flannery KC of the New South Wales Bar, leading the 26-year-old Herbert Vere Evatt. Was it the author of the principal judgment, Sir Isaac Isaacs, then 65 years of age, who, after 14 years on the High Court in continuous dissent, found himself triumphantly in command of a majority, having won the support of the newly appointed Chief Justice Sir Adrian Knox and of the newly appointed Sir Hayden Stark, along with that of Sir George Rich, with Henry Bournes Higgins in agreement, and with Sir Frank Gavin Duffy alone and despondent in dissent. Others then identified by Sir Gerard Brennan as potential contenders for hero of the engineers' case on the bench and at the bar were Stark, who might be portrayed as having played a pivotal role in the argument, and Frank Leverrier KC, who appeared with Henry Manning for the Commonwealth. Among them, Sir Gerard Brennan diplomatically declined to make a choice. Speaking now on the sort of centenary of the engineers' case, I should say the almost centenary of the engineers' case, I share Professor Blackshield's anxiety as to whether there is anything that can now be said about that case that has not already been said, as I seek to give an answer to a slightly modified version of Sir Gerard Brennan's question. Who were the heroes of the engineers' case? Implicit in the framing of that question, Sir Gerard Brennan's framing and my reframing, is acknowledgement that the engineers' case involved a struggle of epic proportions. The conduct of the case certainly had the air of a courtroom drama. In it, the young Menzies was thrust, not unreluctantly, into the role of a leading man. We owe to Menzies himself the colourful description of the dramatic first day of the argument. Sir Robert Menzies gave a flavour of that first day of argument in his inaugural Allen Hope Southey lecture, which has already been mentioned, a lecture given 40 years after the event and at a time when he was Prime Minister. He gave a fuller account to an American audience 6 years after that, shortly after his retirement as Prime Minister. The first day of the argument was here in Melbourne on the 24th of May, 1919. 24th of May. I'm getting confused because I'm treating this as the centenary. It's almost the centenary. 24th of May, 1920. Menzies was appearing before the full court of the High Court to argue on behalf of the Amalgamated Society of Engineers that the Minister for Trading Concerns of Western Australia could be a party to an industrial dispute so as to be subject to the jurisdiction conferred by the Commonwealth Parliament on the Commonwealth Court of Conciliation and Arbitration under the Commonwealth Conciliation and Arbitration Act of 1904. The only other person at the bar table on that day was another junior but more seasoned counsel at the Victorian Bar, the 36-year-old returned serviceman Wilbur Ham, who Menzies described as a master of polished profanity. Ham appeared for the Minister for Trading Concerns. The case law that had developed in the High Court since its establishment in 1903 tended against the argument that the Minister for Trading Concerns could be a party to an industrial dispute, but not implacably so. The case law was generally to the effect that a state instrumentality was immune from Commonwealth legislative control. There were, however, ill-defined exceptions, and it was at least arguable on the basis of the existing case law that there was or should be an exception for state trading enterprises. As the story of that first day of the hearing was told by Menzies to his American audience some 46 years later, with perhaps just a little embellishment, that is precisely the argument Menzies was attempting to make with no great enthusiasm when he was interrupted by the newly appointed Stark. Menzies described Stark as a very distinguished common lawyer whose blunt habits of expression made no exception in favour of a very young man. According to Menzies, Stark looked at him in a grumbling way and said, "This argument is a lot of nonsense." In the words of the older Menzies, who I now quote, "When Stark said this argument is a lot of nonsense, I, in what I later realised to be an inspired moment, replied, 'Sir, I quite agree.' Well," intervened the Chief Justice Knox, never the most genial of interrogators, "why are you putting an argument which you admit is nonsense?" "Because," said the young Menzies, brackets, the old Menzies, would not have dared to do this, close brackets, "I am compelled by earlier decisions of this court. If your honours will permit me to question all or any of these earlier decisions, I will undertake to advance a sensible argument." I, that is the young Menzies, waited for the heavens to fall. Instead, the Chief Justice said, "The court will retire for a few minutes, and when they came back," he said, "this case will be adjourned for argument in Sydney. Each government will be notified so that it may apply to intervene. Counsel will be at liberty to challenge any earlier decision of the court." And that's the end of the quote. The High Court duly reassembled in Sydney roughly 2 months later. The restart date was 26 July 1920, 99 years ago tomorrow. Melbourne Law School is certainly a first mover in the market for 100th anniversary celebrations of the engineers case. All of the states, with the exception of Queensland, were then represented, as was the Commonwealth. Menzies and Ham continued to appear on their own for the active parties in the case. Mitchell and Latham appeared for the states of Victoria, South Australia and Tasmania. Flannery and Evatt appeared for the state of New South Wales. The scene was in that way set for what all concerned must have understood to be a very big battle to begin. Menzies took advantage of the permission he had been granted to argue that the earlier case law affording state instrumentalities immunity from Commonwealth legislative control should be overturned. He no longer needed to rely on an exception if he could overturn the rule. He was ably supported in that endeavour by Leverrier and Manning for the Commonwealth. The old Menzies had evidently forgotten that support when he described the young Menzies as having found himself at the resumed hearing in Sydney at a thickly populated and, from his lonely point of view, hostile bar table. You can say things as you get older. Argument in the engineer's case then proceeded in Sydney over 6 hearing days, concluding on the 2nd of August 1920. It was immediately followed by argument in another case in which the same counsel, other than Mitchell, argued essentially the same issues over another 5 hearing days, concluding on the 9th of August 1920. Judgment was reserved, but not for very long. Written judgments in both cases were delivered barely 3 weeks later, on the 31st of August 1920. The judgment of the plurality in the engineer's case, which was delivered first, appeared in the unusual form of the judgment of Chief Justice Knox and of Justices Isaac, Rich and Stark, brackets, delivered by Isaacs, J, close brackets. From that description, but also from its style and content, no one has ever doubted that the judgment was written by Isaacs. The judgment of the same plurality in the companion case commenced with the explanation that in this case, the court has to apply the principles of law enunciated in the Western Australian Trading Concerns case just decided. In the engineer's case, as what was then described as the Western Australian Trading Concerns case soon came to be branded, as every law student knows, Menzies won the day. The express power of the Commonwealth to make laws with respect to conciliation and arbitration for the prevention and settlement of industrial disputes extending beyond the limits of any one state was held to authorise a law binding on any instrumentality of a state, whether trading or not. In so holding, in one fell swoop, the newly formed majority of the recently reconstituted High Court put an end to elaborately crafted doctrines of constitutional construction which had operated to constrain the scope of both Commonwealth and state legislative power, and which had commanded the assent of a previous majority of the Court throughout its 17 years of existence. Those doctrines, which were grouped under the heading of implied prohibitions, Isaacs then wrote for the plurality, had proven unworkable in practice. They were unworkable in practice, he wrote, because they were unsound in theory, in that they were fundamentally at odds with the nature of the Australian polity. Henceforth, in the language of Isaacs writing for the plurality, the Australian Constitution was to be construed by reference to, quote, ordinary principles of construction, close quotes. Once interpreted according to those ordinary rules of construction, the amplitude of a legislative power expressly conferred on the Commonwealth Parliament was not to be cut back by reference to any notion that it was a function of a court to constrain the scope of a legislative power in order to protect the states from the potential for its abuse. The older Menzies described the method of interpreting Commonwealth legislative powers adopted in the engineer's case as revolutionary. So did Richard Thomas Edwin Latham, and so did Sir Robert Garran before him. Menzies and Garran used the adjective revolutionary in a positive sense, although the ever-moderate Garran used it in a way that displayed an appreciation of the danger of hyperbole and of the importance of not getting carried away with the immediate post-revolutionary fervour. I do not disagree with the description of the engineer's case as revolutionary. Indeed, I have argued quite recently that together with the High Court's decision 68 years later in Cole and Whitfield, the decision in the engineer's case conformed to the characteristics identified in 1983 by the great scholar of the Western legal tradition, Professor Harold Berman, as the standard characteristics of a legal revolution. Both decisions marked a fundamental change from that which had existed before. Both sought legitimacy for the change in what can be described in the language of Professor Berman as a remote past and an apocalyptic vision, or what can perhaps be described more modestly as an original understanding. Both provided the foundation for the subsequent development of a new body of law. Both were transformative of the legal tradition within which they occurred while remaining within that tradition. Both were, in words of Sir Victor Windeyer, which have in the past and no doubt in the present raised the ire of Professor Geoffrey Goldsworthy, a demonstration that in a country which has inherited the common law, its essential characteristic, a capacity to grow and develop as needs change, can govern fundamental law, even the concepts that a written constitution embodies. To adopt the description of the engineer's case as revolutionary, however, is not to suggest that the case can be understood in some way as a one-off event. Much less is it to suggest that the judgment delivered on the 31st of August 1920 is to be explained as the product of an intense 3 weeks of deliberation by 6 justices of the High Court on the basis solely of the 10 days of argument which had occurred during the preceding month. Much less is it to countenance the idea that the judgment then delivered can be attributed to the cleverness of the arguments presented by any one or more of the very learned counsel who had appeared on those days. Like all revolutions, this one had origins. And not unlike the fall of Homeric Troy after the decade-long Hellenic siege depicted in the Iliad, the emphatic rejection of the old doctrine of implied prohibitions that was the engineer's case revolution can only be understood as the denouement of an epic struggle in which heroes were to be found amongst the vanquished as much as amongst the victors. The struggle which occurred during the early history of the High Court and which was brought to an end by the decision in the engineer's case was aptly referred to by Professor Zines as a struggle for standards. Another description of it might be as a contest of ideas or even as a contest of ideals. The champions on both sides were lions of the law and statesmen of the highest order. On one side was Sir Samuel Griffith, who had been appointed the first Chief Justice of the High Court when it was created in 1903, along with the first 2 other justices, Sir Edmund Barton and Richard O'Connor. On the other side was Isaacs, who joined the court with Higgins in 1906. All of those first 5 justices had been intimately involved in the movement to federation. All but Griffith had served in the first Commonwealth Parliament. In the case of Griffith, his involvement in the federation movement had been primarily as a delegate to the Australasian Federal Convention in 1891, where on the steamship Lucinda on the Hawkesbury River, during a weekend break in proceedings, he took charge of the writing of the draft of the Constitution which was to emerge from that convention. His appointment as Chief Justice of Queensland in 1893 necessitated him taking a less active role in the later stages of the movement to federation. In the case of Isaacs, his involvement had been primarily as a popularly elected delegate to the Convention of 1897 and 1898 in debating the final draft of the Constitution, which was to emerge from that convention, to go on to be endorsed in referenda by a majority of electors in each of the Australian colonies, which were to become states, and which was then transmitted to London for enactment into law by the Imperial Parliament in 1900. Griffith and Isaacs held strong and deep differences of opinion about the fundamental nature of the federal compact they and their early judicial colleagues had contributed to creating, and correspondingly about the demarcation of the appropriate role of the High Court in maintaining that compact. Although any summarisation runs the risk of simplification, their competing perspectives can be summed up as follows. Griffith's understanding of the nature of the federal compact, with which Barton and O'Connor were for the most part content to concur, was essentially that of a compact between polities comprising the federating colonies which had become states and the newly created Commonwealth. The role of the High Court was akin to that of a contractual arbitrator, maintaining the polities as potential antagonists within their designated spheres. The understanding was closely aligned with the first of the principles of federation proposed by Sir Henry Parkes and adopted by the Convention of 1891, which was to the effect that, and I'm quoting, in order to establish and secure an enduring foundation for the structure of a federal government, the powers and privileges and territorial rights of the several existing colonies shall remain intact, except in respect of such surrenders as may be agreed upon as necessary and incidental to the power and authority of the national federal government. Isaac's competing understanding of the federal compact, from which the understanding of Higgins was not substantially different, was essentially that of a compact between people. The people of the colonies who voted for those colonies to become states and who also became on federation the people of the newly created Commonwealth. The Commonwealth and the states were not contracting parties, but functional representatives of the same unified people. The High Court had no role in policing the exercise of power by the people's representatives beyond that which the people themselves, in nationwide referenda which adopted the Constitution, had clearly committed to the Court by the terms of the Constitution. For the Court to attempt to carve out for itself a more extensive role was unnecessary, because the people acting electorally could be expected to look after themselves. For the Court to attempt to do so was also improper, because to do so involved an overreaching by the judicial arm of government into the political arena, where it had neither the skill set nor the mandate to interfere. Whereas Griffith's understanding was closely aligned to the first of the principles of federation adopted in the 1891 Convention, Isaac's understanding aligned more closely with the first of the revised principles of federation proposed to and adopted by the Convention of 1897 and 1898. It was to the effect, and I'm quoting, that in order to enlarge the powers of self-government of the people of Australia, the powers of the several existing colonies shall remain intact, except in respect of such surrenders as may be agreed upon to secure uniformity of law and administration in matters of common concern. Writing for the plurality in the Engineers case, Isaacs announced the ascendancy of his understanding over that of Griffith's when he emphasised floridly and repeatedly that the fundamental problem with the old doctrine of implied prohibitions, which Griffith had until then caused to prevail, was that it was founded on a notion of necessity for judicial intervention in the relationship between the Commonwealth and the states, which gave insufficient attention to the role of the people. Extravagant use of the granted powers in the actual working of the Constitution, Isaacs wrote, is a matter to be guarded against by the constituencies and not by the courts. And I'm quoting Isaacs, when the people of Australia, to use the words of the Constitution itself, united in a federal Commonwealth, they took power to control by ordinary constitutional means any attempt on the part of the National Parliament to misuse its powers. If it be conceivable that the representatives of the people of Australia as a whole would ever proceed to use their national powers to injure the people of Australia considered sectionally, it is certainly within the power of the people themselves to resent and reverse what may be done. No protection of the High Court in such a case, Isaacs went on, was either necessary or proper. Thus emerged from the fray a new doctrine of the High Court. The doctrine was new, but the perspective was not. Isaacs had adhered to it unwaveringly since the time of his appointment as a justice in 1906, and he had espoused versions of it not only in submissions as counsel during the 5 years of federation which preceded that appointment, but also in his contributions to the convention debates of 1897 and 1898. What was different by 1920 was that Isaacs' understanding of the federal compact, rather than Griffith's, had come to be more in keeping with an altered national mood. In the language again of Windeyer, and here I quote, "In 1901, many men and women in Australia felt strong ties with the colony to which they belonged. They had not begun to think of themselves as belonging to the Commonwealth. But by 1920, a new generation had arisen who thought of themselves as Australians and of Australia, not a state, as the country to which they belonged. That public law, whether given by courts or by legislators, should be responsive to public sentiment is not surprising. And since an entrenched constitution is not easily altered, as other statutes are, it is not surprising that developing case law puts an ever-growing body on its bones, which may come to be seen in unexpected new dimensions. In the language of Professor Freund, a new era had dawned. The climate had changed. Much of the change that had occurred within Australian society was attributable to the experience of the First World War. With the coming of the war, as Sir Owen Dixon later put it, the power of the federal legislature over naval and military defence leaped into the foreground of the scene of constitutional controversy, where it overpowered other questions. Not only did it reduce in the public eye the stature of the states, but it accustomed the High Court itself to the exercise by the central government of an ample and all-pervading power. Nor had the High Court itself been shielded from the ravages of that war. 3 of its sitting members, Rich, Higgins and Gavin Duffy, had lost sons in the conflict. Griffith himself is reported to have said that he found it hard to do ordinary work in such anxious times. When the war came formally to an end on the 11th of November 1918, Griffith called an extraordinary formal sitting of the High Court just 2 days later. There he went on record as acknowledging that the world was no longer the place it had been before. And here I quote from what he said on that occasion: "The task before the nation," Griffith then said, "involves the recasting of conditions and the revision of doctrines that have long been regarded by multitudes as axiomatic and fundamental. What appeared to Griffith to be the matter most urgently calling for treatment was the question of the mutual relations of the people of a state to one another. The old, deeply rooted idea of division into classes who are natural enemies and whose destiny and duty are to prey upon each other," he then said, "must give place to the sense of equality and of the paramount duty of every man to bear his part of the load of his neighbour's burdens as well as his own. A radical change of mental attitude, not in one part only of the community," Griffith then said, "was essential to a wise performance of this task," but he did not despair of the result. Less than a year after he made those remarks, at the age of 74, Griffith was forced by ill health to tender his resignation. His resignation was accepted with effect from the 17th of October 1919, making way for the appointment of Knox as his replacement. O'Connor had died in office in 1912, his death leading to the appointment of Gavin Duffy. Barton died in office at the beginning of 1920. It was Barton's death that led to the appointment of Stark. Not only had the climate of the era changed radically, but the composition of the High Court had by that time changed radically with it. As fate would have it, Griffith died on the 9th of August 1920, between the conclusion of the hearing of and the delivery of judgment in the engineer's case. Quite what Griffith would have made of the judgment in the engineer's case, we can only speculate. No doubt he would have felt the disappointment of anyone who has harboured deep convictions that have come to be rejected by others. But in light of the openness he had expressed less than 2 years before to the revision of the doctrines long regarded as fundamental, it seems unlikely that he would have been wholly resistant to the change that occurred. There is reason to doubt that his reaction would have matched that of his successor, Sir Garfield Barwick, to witnessing his long-held constitutional views being overtaken by the judgment in Cole and Whitfield. Really laughable, terrible tosh, Barwick is fabled to have said. Of the engineer's case, in contrast, Barwick solemnly warned his successors in office to be very wary that its triumph is never tarnished. What Griffith would certainly have known of and appreciated in his lifetime were remarks made by Isaacs at a ceremonial sitting to mark Griffith's retirement, which Griffith was too ill to attend. Speaking for himself and other members of the High Court, Isaacs said that he bore willing testimony to the great learning and ability and the fearlessness and wholeheartedness which Sir Samuel Griffith brought to the performance of his duties in his great office. He went on to acknowledge that whatever status the High Court then held in the confidence of the Australian people was due in no small measure to the wisdom and capacity of its illustrious head. As Isaacs' remarks indicate, there is more to the heroism of Griffith in defeat than his valiant pursuit of a doomed cause, just as there is more to the heroism of Isaacs in victory than his persistence and longevity. Stronger than the differences in the perspectives on federation which divided Isaacs and Griffith was the institutional commitment which united them, to those differences being resolved within Australia by an Australian High Court attuned to contemporary Australian conditions. As the more senior of the two, it fell primarily to Griffith to establish and defend that united position. Griffith is credited with having devised the compromise reflected in Section 74 of the Constitution that no appeal was to be permitted to the Privy Council from a decision of the High Court on any question as to the limits inter se of the constitutional powers of the Commonwealth and those of any state or states, unless the High Court was satisfied that for any special reason a certificate should be granted to permit such an appeal. It was then Griffith as Chief Justice who stared down the Privy Council and state Supreme Courts alike during the first 4 years of the High Court's existence, firmly to establish the High Court's authority, ultimately to resolve the competing perspectives on which he and Isaacs were divided. In Deakin and Webb, writing for himself, Barton and O'Connor, Griffith overturned a decision of the Supreme Court of Victoria, which had chosen to follow that court's own previously expressed view of a pre-Federation Privy Council case pertaining to the Canadian Constitution, in preference to the doctrine recently laid down by the High Court in Dembden and Pedder as pertaining to the Australian Constitution. With the support of Barton and O'Connor, Griffith went on in Deakin and Webb to refuse to grant a certificate permitting an appeal to the Privy Council. The responsibility which the Australian Constitution cast on the High Court, Griffith then said, was to determine for itself any question as to the limits inter se of the constitutional powers of the Commonwealth and the states. The High Court would be guilty of dereliction of duty, tantamount to a breach of the trust that had been confided in it by the Australian people, were it to decline to accept that responsibility unless it were in a position to say, in intelligible language, that there was some special reason capable of being formulated why the Privy Council was, and why it was not, the proper ultimate judge of the question. No reason, said Griffith, then existed. When in Webb and Outram, the Privy Council, having chosen to entertain a direct appeal from another decision of the Supreme Court of Victoria, purported to overrule Dembden and Pedder and Deakin and Webb, Griffith refused to budge. In Baxter and the Commissioners of Taxation of New South Wales, with the support then of all other of the then 5 members of the court, Griffith held that the Privy Council decision in Webb and Outram was beyond the jurisdiction of the Privy Council. With the support of 3 of those 5 members, he held that Dembden and Pedder and Deakin and Webb should continue to be followed. And again, with the unanimous support of his colleagues, he held that a certificate permitting an appeal to the Privy Council from the High Court's own decision should not be granted. In Flint and Webb, decided the very day after Baxter and Commissioners of Taxation, Griffith again led a unanimous High Court in refusing to grant a certificate to permit an appeal to the Privy Council from a decision in which the majority applied Dembden and Pedder and Deakin and Webb, making clear that the existence of the contrary decision of the Privy Council in Webb and Outram did not amount to a special reason for granting a certificate. We might disagree strongly with each other about the fundamental nature of the Australian federal system, the first 5 members of the court were in effect saying, but none of us have any doubt at all that it is our collective duty to the Australian people to work out the problem for ourselves. Between Baxter and the Commissioners of Taxation in 1907 and the Engineers case in 1920, a certificate permitting an appeal to the Privy Council was granted under Section 74 of the Constitution in only one case. The special reason in that case was found in the High Court, constituted by only 4 justices being evenly divided. Nearly a year after judgment was given in the Engineers case, Mitchell, then leading Dixon and appearing on behalf of the Minister for Trading Concerns of Western Australia, as well as for New South Wales, Victoria, Tasmania, South Australia and Western Australia itself as an intervener, applied to the High Court for certificates permitting appeals to the Privy Council from the judgments in the Engineers case and in its companion case. The applications were opposed by Menzies and Leverrier, each relying on Deakin and Webb and Flint and Webb. The applications were refused by the High Court without the court giving reasons. Those were the days. In a last-ditch counter-revolutionary move, Dixon, who by then had been appointed KC, was dispatched to London to attempt, on behalf of the Minister for Trading Concerns, to petition the Privy Council for leave to appeal from the judgments of the High Court, notwithstanding the absence of a certificate under Section 74 of the Constitution. I'm sure it was a nice trip. Even if Dixon had somehow been able to overcome the jurisdictional difficulty, his argument on the merits was a very big ask. As Garron later explained it, Dixon essayed the ambitious task of convincing the Privy Council that when the two courts had originally been in disagreement, the Privy Council had been wrong and the High Court right, and now that the High Court had come round to the Privy Council's view, they were both wrong. The outcome, again in the words of Garron, was that the Privy Council gave no indication of being impressed by the argument, but they refused the leave on the ground, which from the Australian point of view was even more important, that the questions involved were clearly questions of constitutional power, which under the Constitution, the Privy Council had no jurisdiction to entertain without a certificate from the High Court, which in this case was not forthcoming. So it was concluded. Professor Anne Toomey has noted that the conclusion in the engineer's case was not uncontroversial in its day. Indeed, the decision prompted one newspaper to go so far as to declare that the High Court had become the Constitution and that the way to change the Constitution had become to change the composition of the High Court. Mitchell, amongst other senior legal practitioners, gave evidence before the Royal Commission on the Constitution in 1929 to the effect that the stability of Australian constitutional law would be enhanced were Section 74 of the Constitution to be amended to remove the restriction on appeals to the Privy Council. The suggestion fell flat. Australian sentiment, reported the Royal Commission, was then, as it had been in 1900, in favour of confining the right of interpreting the Constitution to the High Court of Australia. Never again did the High Court grant a certificate under Section 74 of the Constitution. Appeals to the Privy Council from Australian courts were in due course progressively abolished and abolished in their entirety by the Australia Act of 1986. So who then were the heroes of the engineer's case? Menzies certainly deserves to appear in the credits. So does Leverrier. Extrapolating from Professor Helen Irving's observation that there were founding mothers as much as there were founding fathers, I acknowledge that there may be others whose significant contributions were behind the scenes and who have not received the credits which they are due. Top and equal billing, however, I suggest, must go to Isaacs and to Griffith. Looking back on the revolution that was the engineer's case, Isaacs to what was decided and Griffith to who decided it, each would be entitled to invoke the words of the poet Virgil, which Isaacs chose to use to end his tribute on the occasion of Griffith's retirement. Coram pars magna fui, it is something in which I played a great part. So thank you for listening.
Good evening, ladies and gentlemen and members of the Southey family. With Adrienne, I am the co-host of tomorrow's Centre for Comparative Constitutional Studies 2019 Constitutional Law Conference. And when one seeks to convene a conference every 2 years that can bring practitioners, leading practitioners and leading scholars together to discuss large, small, current and past issues of Australian public law, we keep our eye in that task on the larger horizon of what is coming up in the Australian historical landscape as well. And it was with an eye to the fact that the engineer's case was going to have its centenary in 2020 that we resolved that we would like to address that topic. Now, quite clearly the facts are not on our side in the sense that and this has been commented on very graciously by His Honour, that the facts are not on our side, that the centenary is this year, but I would simply respond that it's part of the CCCS to be committed to remaining ahead of the curve at all times. And equally, it is a commitment of the CCCS to aim high, and it was in that spirit that we resolved, Justice Gageler, to approach you to speak to the topic. We were delighted with your very swift and warm warm reply, and we're again delighted tonight to see how that acceptance has brought such enjoyment and indeed erudition to such a large audience. So if you could join with me in thanking Justice Stephen Gageler for tonight's lecture.